Hello, everybody. We're getting ready for the show, and it'll start in about 1 minute, also known as 1/10 of a billable hour. Thank you very much for coming. Please put your candy wrappers away. Please don't slurp your Bloody Marys really loud during the presentation. This is mathematical, so we do recommend that you not operate heavy vehicles while you listen to this presentation. By the way, this is the best part of the presentation. The worst part is yet to come. Thank you for being on time, and have a fantastic Memorial Day. I'm going to go draft some documents now, a SLAT and a qualified personal residence trust and an installment sale document for one of you. And then I'll be back later maybe to check on you. Thank you very much, and sorry if I misspelled your spouse's name and got the wrong middle initial. Okay, welcome to this presentation entitled Nuts and Bolts of Federal Estate Tax. And my name is Alan Gassman. I'm an attorney in Clearwater, Florida, and I am nuts about the federal estate tax and about all of the wonderful attention being placed on the federal estate tax. My first estate tax course was in 1981 at the University of Florida, and Professor C.D. Miller, and probably some of you on this talk had Professor Miller, said that the estate tax is the only voluntary tax because there were so many ways to avoid it. The people who decided to pay estate tax would pay a lot of it, and the people who decided not to pay estate tax could pay zero estate tax, or at least a lot less than what they would have paid. So one of my favorite authors is Professor Drucker. He wrote, I think, 62 books on business. And one of the things that Professor Drucker says is that in order to do something good, you have to stop doing something else. So I hope that everyone who listens to this talk today, after recovering from listening to the song The Taxman, will think about what you need to do to make the time to understand and to work with the federal estate tax. Now, I have the usual PowerPoint deck. Brandon Ketron is not here with me today. He actually has a life as compared to me. The presentation we're giving does not qualify for continuing education credit, basically because it's just not good enough. 1 hour after this event, you will all receive an auto email from GoToWebinar with the recording and the PowerPoint slides and the handouts, and then separately, we will be sending you the Excel spreadsheets that I'm quite proud of. This is what you'll be getting in about an hour. So after the presentation, I'll get about 15 or 20 emails from people asking how they can get the materials, giving me proof that they did not listen to the webinar. If you go to the website of cpaacademy.org and sign up for free, you can see a lot of our other webinars, including one on spousal limited access trusts that we filmed on April 30, and the mathematics of estate planning for CPAs that we filmed on May 11. Not so free, some 90-minute talks that we've given, really deep dives, especially for advisors. I think they're worthwhile, but I'm prejudiced. And but there they are in case you're interested in them. And then our EstateView software that I'm very proud of, we probably won't be showing today, but if you can go to the YouTube and look up EstateView, and you'll get a demonstration of how all that works, and we're very proud of it. So enough of this advertising and shameless self-promotion. Let's get to the federal estate tax system and how it works. Every person living who is a U.S. citizen has an $11,700,000 estate tax exemption. It started as a $5 million exemption in 2013, and it went up with inflation each year, and then it doubled under President Trump and the 2017 Tax Act or earlier. So If you have not made large gifts in the past and you are living a U.S. citizen, today you have an $11,700,000 exemption that you can use for gifting or for dying. So it is what we call a combined exemption. If I give you $1 million tomorrow, then my exemption will be $10,700,000. And when I die, I'll only be able to pass $10,700,000 free of federal estate tax. Now, when a person dies, besides everybody being very sad, the first thing they do is they add up the person's assets. Usually that takes place before the funeral. And if the person's assets were less than whatever her remaining exemption amount was, then there's no estate tax. And if the gross value of assets was less than that amount, then there is no filing of an estate tax return. But if the person had more than the $11,700,000, then there will be the filing of an estate tax return and an estate tax unless the deductions are sufficient to avoid estate tax. And the three primary deductions are: one, my favorite, the cost of administering your estate. And if you want to do me a favor, don't use revocable trust so that we can charge you extra for a probate. The second deduction is marital deduction. If I die and I leave my assets directly to my spouse or into what we call a marital deduction trust, also known as a Q-tip trust, because the surviving spouse does not clean their ears as often. It also stands for Qualified Terminal Interest Property Trust. So you are worth $20 million, you die, everybody's sad, they add up the assets are $20 million, they're not as sad anymore. $11,700,000 could go to your children, your friends, or to a special trust called a family trust or a bypass trust, which can benefit your spouse and never be subject to estate tax on the second death. So that's why we sometimes call that a credit shelter trust or a bypass trust or a family trust. And the surviving spouse can be the trustee of that trust as long as she is limited to receiving what she reasonably needs for health, education, maintenance, and support. And that trust can grow and never be subject to estate tax. And then on the surviving spouse's death, that trust can divide into separate trusts for the children who are so sad that their parents died. And each child could be the trustee of his or her own trust and receive amounts as reasonably needed for health, education, and maintenance, and that trust will never be subject to estate tax. And for one of our clients, we are placing these trusts in South Dakota. And the reason we're placing them in South Dakota is that South Dakota has a 990-year statute of limitations. Rule against perpetuities. So a trust in Florida, unfortunately, can only go 365 years. But in South Dakota, 999 years, and he's going to provide that no one in his family can disrupt the orderly succession of trusts from one generation to the next, where there will be no estate tax at any generational level for 999 years. And I wish I could be here at 999 years to see how that works out. The assets above the 11,700,000, they could go outright to the surviving spouse, but then they might be lost. So they could go into a Q-tip trust that pays all income to the surviving spouse. In order to qualify for the marital deduction, it must pay all income to the surviving spouse, whether the spouse needs it or not. But by the way, they typically do need it to pay for their next spouse. The Q-tip trust and the assets of the surviving spouse will be counted as assets of the surviving spouse when the surviving spouse dies. So in my example, someone dies, leaves 20 million, 11 million 7 goes into the family trust. 8,300,000, yes, I added it up in my head all by myself. 8,300,000 goes into the Q-tip trust. Now, when the surviving spouse remarries and inherits from the new spouse and has a $30 million net worth, plus the 8,300,000 in the Q-tip trust is now worth 24 million. All of that is subject to federal estate tax on the second death. So more needed to be done. Now, the 11,700,000 is inflation adjusted, but it doesn't go up with the consumer price index. It goes up with chained inflation. Now, chained inflation has nothing to do with sadomasochism, although it was passed by Congress, and it does hurt because it only goes up by about 2/3 of the consumer price index. So it's been going up almost 2% a year, or a little bit less than that. But the exemption is scheduled to go down to half of that amount January 1, 2026. And if that falls on a Saturday, I'll be here and we will talk about it. But it may happen sooner. Certainly, there are many proposals right now. The Bernie Sanders proposal would bring that down to 3,500,000 million effective next January. I don't think that's going to happen. His proposal would also bring the gift tax exemption down to $1 million next January. I don't think that's going to happen. The Biden proposals do not touch the exemption amount or most of the other things we're going to talk about. The Biden proposals as of now say that when you die, even though you're not Canadian, you will be treated like under the Canadian tax system, which is when you die, there will be a capital gains imposed as if all your assets were sold on the date of your death. But that will probably not apply to assets that you leave to a spouse. It probably won't apply to a certain value of assets, and it probably won't get passed. The Wall Street Journal has announced that at least 4 Democrats have said no way to that, but we will see what happens. On the left is an irrevocable life insurance trust. Now, if I die owning life insurance, it can pass to the family trust, but that means that there's going to be more going to the Q-tip trust. So my family will save taxes if I can keep the life insurance outside of my estate for federal estate tax purposes. And I can do that by putting it into an irrevocable life insurance trust. My spouse or children can be the trustees. I pay the premiums. They're treated as gifts under the $15,000 a year exclusion. And then if I die more than 3 years after an old life policy was placed in a trust, it's not in my estate, even though it benefits my spouse and my descendants. So that is the irrevocable life insurance trust. Bringing us to slide number 2. So slide number 2, somehow we're already on page 24. That's why I always skip the introduction to a book and the preface, because I can always start around page 24. And here you have spouse 1's revocable trust, spouse 2's revocable trust, an irrevocable trust for the lovely children and grandchildren, and a SLAT, a lifetime bypass trust. So spouse 1 is very, very wealthy. Spouse 1 may want to give some assets to spouse 2. So if spouse 2 dies first, that 10,7 million can be funded for spouse 1. Hopefully spouse 2 won't leave spouse 1 if that happens. Spouse 1 looks pretty attractive in this picture. So then they could gift up to $30,000 a year to their children, or because they don't want their children to ever spend it while they're living or to see that happen, or at least not right away, they could make their $15,000 per child gift to an irrevocable trust, having a trustee other than the 2 of them, And so if they have one child, they could each give $15,000 a year. Therefore, they could give $30,000 a year to this trust for that child every year. So over 10 years, you can give $300,000. If that's growing at a 7% interest rate, it's going to be worth about $450,000 after 10 years. And that's just per child. Now, we have clients that have, believe it or not, over 100 descendants. Can you imagine what the Hanukkah party is like for 100 descendants? 100 times 30, $3 million a year they can gift to a trust. Now, when you gift to a trust, in order to have it qualify for the $15,000 a year exemption, you have to give the descendant or the person who has that exemption a withdrawal power. So the trust says, whenever I put $15,000 in this trust, my daughter Molly can take the $15,000 out within 30 days of when I put it in. And if she doesn't take it out, it's going to stay in that trust, and then it's going to be up to the trustee to determine if and when there will be a withdrawal or a distribution to the child. And sometimes we put the in-laws in there. With the son-in-law, daughter-in-law have the ability to also withdraw up to $30,000 within 30 days of the contribution, even though if they divorce the child, they'll no longer have any benefit from the trust or a withdrawal power. Okay, then what does the spousal limited access trust do? It's not like a fast pass at Disney, although it could work the same way depending upon how things go in the marriage. Spouse one makes a $11,700,000 gift to the Lifetime Bypass Trust. Spouse two is the trustee. Spouse one has now used all of her $11,700,000 exemption. All of the future growth in that trust is not going to be subject to estate tax in spouse one's estate or spouse two's estate, even though this trust is going to be able to be spent for the health, education, and maintenance of spouse two. So this gets it out of spouse one's estate, but spouse one knows that half of spouse one's household expenses are going to be paid by this trust if they ever run out of assets. And if this trust is formed in Nevada, South Dakota, Alaska, Delaware, or one of the other asset protection trust jurisdictions, spouse one might be added back to the trust if there was ever a creditor debacle or an economic tsunami that would cause spouse one to otherwise be on the street. If spouse two divorces spouse one, then this SLAT, Spousal Limited Access Trust, may divide in half, be half held for spouse two and half held for the descendants under the control of spouse one. Or if this is all spouse one's premarital assets going into the SLAT, when spouse two divorces, spouse two is out of the SLAT and the next spouse is in the SLAT as long as they're married, so that spouse one can immediately get benefit and attract a new spouse. Now, somebody just asked, and thank you very much, James, how are these trusts taxed? And the answer is not at all, because a revocable trust is not considered to exist under the income tax laws. And an irrevocable trust is also what I will call disregarded if the grantor of the trust retains the right to replace trust assets with assets of equal value or certain other rights. So this is so nice. I could put $11,700,000 into a trust for Marcia, my wife. She could be the trustee. She can get what she needs for health, education, and maintenance if ever we need it. And we can pay the income tax on the trust income because the trust is disregarded for income tax purposes. And over time, that makes a very, very large difference. If you run the numbers on a trust paying its own taxes and it reaches the highest bracket after about $12,000, $800,000 of income. You run the numbers on that versus you paying the taxes for that trust. If it's a 2% difference, then you're doubling your money every 25 years. So it makes a very large difference. And that's why we have to be careful when we draft these trusts, to be able to have them be disregarded initially, but then not so much later. Now, spouse one, believe it or not, is a control freak. I bet you never met one of those. So spouse one doesn't really want spouse two to have control. So spouse one, he's pretty smart, puts $1,500,000 worth of assets into an LLC and retains the permanent right to manage it, can't be kicked out from management because of the LLC operating agreement. And therefore, the 100% ownership of the LLC is only worth $11,700,000 according to an expert that I can find you. So now you have $15 million transferred to an LLC owned by a spousal benefit trust, 15 million really, and spouse one is controlling it. Besides estate tax planning, you have another job. Your job is to know what you would lose if there was a horrific judgment against you. Welcome to the United States of America, where anyone can sue anybody else. Car accidents, please don't let anyone drive your car but you. Please don't touch alcohol and drive a car. Call an Uber, take a bicycle, whatever it takes. Remember, if you are over the legal limit and you somebody runs in front of your car and dies, you're going to prison for at least 10 years, even though you may not have been at fault in the accident. It's called vehicular manslaughter. Don't drink and drive. Don't let anyone else use your vehicle. Don't ever leave your house. Don't ever hire anyone. Because if you hire someone, any damage they do could be your responsibility. So please know, if you get sued, what would you lose? If your spouse got sued, what would she lose? If you both got sued, what would you lose? Make sure that the estate plan not only handles estate tax, but also handles creditor claims. And we do a lot of creditor protection work and consulting, and it hits the hand unexpectedly for many people. So please be careful out there. Okay, and I am getting a lot of questions here in the questions box, and I'm going to answer every single question that I know the answer to. And also, I apologize that apparently there was some audio problems early on, and we'll go ahead and replay those first few minutes for those of you who had the audio problems, but it wasn't very good anyway, I assure you. All right, so now we go to the slides that say what I just said. Slide 26 is a year old, so the exemption used to be $11,580,000. The gift tax exemption, what you can give it each year without counting against your exclusion, is $15,000. I think that's going to go to $16,000 next year. It is inflation adjusted. Now let's talk a little bit about charity. And I've been blessed to help a lot of people give a lot of assets to charity and save a lot of federal estate tax. So besides there being a marital deduction for what you give your spouse now and what you give your spouse on death, there's also an unlimited charitable deduction. So for example, if you have a $20 million estate, if you want to die and leave $8,300,000 to a family foundation, the foundation can be controlled by your spouse and descendants. They can earn reasonable amounts running the foundation for charitable purposes. So would you rather have 40% of $8.3 million go to the US government and the rest go to your family, or would you rather have the whole $8.3 million go to charity? And many clients would rather have it go to charity. And if so, the next question is, why don't you just give us some of it now and get the income tax deduction, and then you'll be that much further ahead. But if you are interested in paying zero estate tax and leaving your children as much as possible, and you don't mind charity, then the charitable lead annuity trust may be your chess player. The big picture on the charitable lead annuity trust is that I can today or upon my death put assets into a trust that will pay charity monies for 10 to 15 to 20 years. And what's left in the charitable trust after the term of years can go to my children estate tax free. And if I use all the gadgets available to my estate tax planner, I can know that somewhere between 50 and 70% of what I put into that CLAT is going to end up going to my descendants, and the rest is going to go to charity, and I can get an income tax deduction now. So if you don't mind helping a charity, which could be a public charity that may give you a lot of recognition, or your own private foundation, the CLAT is a really, really good player. And remember, if you give it now, you can also get an income tax deduction. So, you know, grandma's not looking so good, not because she's unattractive. I mean, that grandma is old and unhealthy. She may want to do a CLAT while she's still living. Maybe she should sell all her assets and then offset the capital gains tax by doing a CLAT, getting a full tax deduction on assets that are going 50 to 60% to those lovely grandchildren. So give that some thought. On the federal estate tax, there is a payment plan. If you have an active business, you can die, and to the extent of estate tax on the active business that's retained by your family, interest only for 4 years and then ratably over 10 years. That's a reason that if you have a lot of rental property, we want you to be active landlords, not passive landlords. If you're a triple net landlord, that's not going to work. But if you're providing janitorial, maintenance, percentage rent type of situations, you can get this Section 6166 payment plan, and you want to make sure you know about it. What is the Crummy power? Well, once upon a time, there was a brave taxpayer named Mr. Crummy, and he set up a trust and put the $3,000 in it, gave his daughter 60 days to withdraw it. She didn't withdraw it. He said that that qualified under what was then the $3,000 a year a gift tax exemption. IRS said no. Tax court said yes. And therefore we have the Commissioner v. Crummy, and that's why we call them Crummy powers. And when we have a trust that is disregarded for income tax purposes, they called that in 1968 a defective trust, because back then the individual rates were higher than the corporate the trust rates. So you didn't want to disregard a trust, and if you accidentally did it, it was called defective. So I apologize for telling you, and many of my clients have crummy defective trusts, and that's just the way it is. It's a confusing world out there. There is a 3-year rule where if I give away life insurance to an irrevocable trust, or if I retain what's called an income interest or a retained interest in an asset that I gave away, I have to get rid of that more than 3 years before I die, or it will still be in my estate. So some clients, we figure out there's a problem, we fix it, but then we buy inexpensive term life insurance, maybe just a 10-year policy. So if the client dies within 3 years, the risk of that estate tax is handled. Many of you have life insurance that's in or going to go into an irrevocable trust. And when you pay the premiums on that life insurance, you're using your $15,000 per person per year exemption. But there's possibly a better way to do it. For many of you, it's better to use what's called a split dollar loan arrangement. So if the premium on my policy is $50,000 a year, then I put $50,000 a year into the life insurance trust that pays the premium. And when the life insurance policy matures, which is a polite way of saying when I kick the bucket, my estate gets paid back, or my trust gets paid back the $50,000 I put up. at interest at a very, very low rate. So then I can use my $15,000 a year exemption to be gifting discounted LLC interests every year. Okay, Jeffrey wants me to mention hanging crummy powers. Now, this does not mean that you hang a person, but if I give my child a $15,000 withdrawal power and she allows it to lapse, then under the estate and gift tax laws, she may be considered to have made a $10,000 transfer to that trust. I can avoid that by saying that she can go ahead and withdraw that amount later. And that's called a hanging crummy power. And some of you do have hanging power, crummy power language in your trust agreements. So that's generally what it is. Now, a very famous tax court case has just come out a week and a half ago. I'll be glad to send you my draft article on it. It's called the Morissette case. And Mrs. Morissette helped her sons buy life insurance on their lives. So she had her sons, they were in their 40s and they didn't like each other, and they wanted to make sure that one of them would be bought out of the family business if he died. So Mrs. Morissette loaned $10 million to each child's life insurance trust, and she was going to get her $10 million back when the child died, which would be 30 to 40 years from now. So Mrs. Morissette advanced $30 million for this life insurance arrangement, and then she died. And they valued her ability to be repaid at $7,500,000, and they put that on the estate tax return. She's going to get repaid $30 million in 30 or 40 years, value $7,500,000. Believe it or not, the IRS did not like this, and they attacked the arrangement vehemently. It is a common arrangement that the IRS considers to be abusive, but within the tax law, it is clear that when you die, things are valued only at what a willing buyer would pay a willing seller. And what would you pay me for the ability to get paid $10 million when my 42-year-old healthy son dies? You would not give me $10 million for it. You would give me a lot less than that. So, but Mrs. Morissette's trust said, when I die, you can go ahead and forgive these if you want to. And that's pretty much what the trustee did. She died, and the trustee gave each of the trusts the ability to get paid to themselves, which basically canceled this out. So the tax court judge said, guess what? Pigs get fat, hogs get slaughtered. This is worth almost $30 million. There was some other technical analysis in the case that we found to be very interesting. The judge said you can't just do a split dollar agreement. You have to have a business purpose for it, or in our opinion, at least charge a little bit of interest. So I know a lot of you on this call are tax professionals. It's a 122-page opinion, and one tax professional to another, I will tell you, this judge did not do a favor to split dollar life insurance. You have to run a 2036A2 analysis. You have to run a 2703 analysis. You got to change your oil and transmission fluid and worry about whether it's going to work. But in our opinion, the loan regime, if you charge a little bit of interest, it doesn't have to be paid until the death, then split dollars should still work, and there should be a reasonable discount. Recently, there was a large settlement where the IRS gave a 30% discount on what they call this intergenerational split dollar. 529 planning. Yes, you can prepay educational expenses, and you can also open what's essentially a mutual fund arrangement called a 529 plan. And that can then pay college expenses, tuition up to $10,000 a year from kindergarten through high school, for graduate school, and living expenses. And if they don't use it, it can go to someone else. And as opposed to only putting $15,000 a year in, you can use this year and the next 4 years, put $75,000 into a 529 plan for your grandchild or anyone on earth, and declare that to be a gift over the next 5 years. And as long as you live the 5 years, it's out of your estate. So the 529 planning is a good way to get a long-term commitment. So there's a slide on defective trusts. And there we talk about defective crummy trusts. And now I want to go and I want to talk, and by the way, we're going to come back to some simpler topics. I'm going to talk now about 2036, and an asset transferred is still in your estate for estate tax purposes if there was any understanding that you would benefit from that asset, or you retain the right, exercisable in conjunction with anyone else, to control if and when the property will be received by others. And there were 2 cases in the last 10 years, Powell and Strange, where the courts did not like what the people did, and they said, because you had the right to vote on whether what you gave away would ever be distributed, it is in your estate for estate tax purposes. So when we review complicated estate plans, we often find 2036A issues, and we fix them, and we advise the client to please live at least 3 years after we get this fixed, and that is the 2036A. What is an inheritance trust? An inheritance trust is a trust that helps you and benefits you for your lifetime, as opposed to being taxed in your estate when you die. So please do not leave me an inheritance. If anyone out there would like to leave money to me in your will and trust, read my Forbes article here and form an inheritance trust, or I will form an inheritance trust, and then you can make the beneficiary of whatever you were going to leave me the inheritance trust. Then I want to mention portability, and it looks like I'm going to go about 3 or 5 minutes over, so just consider this to be the bonus round. Portability is pretty neat. If I die and I leave everything to my spouse, then I've never used my $11,700,000 exemption, and she gets it. So if your spouse dies and leaves $6,700,000 to her children and nothing else, she doesn't have anything else, then there's $5 million left of her exemption that automatically goes to the surviving spouse if a proper election is made on an estate tax return. So now the surviving spouse has $16.7 million of exemption. But it does not grow with inflation. That extra $5 million does not grow with inflation. It does not cap the value of assets as would apply under a credit shelter trust. And if the surviving spouse remarries and the new spouse dies first, you are reduced or increased to the next spouse's portability allowance. So for this reason, if Bernie Sanders' plan passed, a lot of people would be hoping that their relatives died before the end of the year so that the portability allowance would be at least $1.7 million. Going back to an article I wrote in 2012 for Estate Planning magazine called When to Unplug Great Grandpa. I wrote the article fully expecting that the editors would change the name, but I guess they forgot to do that. So here's what a lot of wealthy people are doing. You take assets, place them under a limited liability company. Spouse 1 or spouse 2 forms a trust for spouse 1 and descendants called a SLAT. Spouse 1 forms an irrevocable trust for descendants because of something called the reciprocal trust doctrine. We don't form trusts for each other. A tiny bit of the LLC goes to a trust where somebody else controls distribution decisions. Now, a seed capital gift is made by each spouse to each trust, and each trust buys an LLC interest for a note. So let's say that we put $30 million into the LLC, and now 99% of a $30 million LLC is worth $20 million because of discounts. So this trust buys 49% of the LLC for a $10 million note. This trust buys 49% of the LLC for a $10 million note. Spouse 1 and 2 are owed $20 million, and there's $30 million in the LLC. Spouse 1 and 2 pay all the income tax. When the LLC is worth $60 million in 10 years, they're only owed $10 million each. The LLC might liquidate. They get $10 million each, and the trusts have $20 million each. So that is called the installment sale to the defective grantor trust. And then there's other things called grats. With a grat, with this arrangement, I have to worry about maybe the IRS would say that I was too aggressive and I might owe a gift tax. With a grat, it's almost the same thing. It's a little bit more complicated. But if the IRS doesn't like what I did, they make me pay more back. So an example of a very effective grat arrangement would be a company making $300,000, making $3 million a year. The company's worth $15 million. I sell 10% of the company to a grat, and it has to make payments of $120,000 a year to me. So now that 10% of the company is out of my estate for estate tax purposes. The grat receives $300,000 a year as its 10% of the dividends, pays me $119,000, invests the rest at 7.5%, has $2.5 million plus 10% ownership at the end of the 10th year, and there was zero gift made. The IRS comes in and says that was too good to be true. They can't get a gift tax out of me. They can only get higher payments. So that is the grantor retained annuity trust. I've got literature here on our JEST, Joint Exempt Step-Up Trust. Mom and dad put $12 million in the JEST trust. Mom dies. The whole $11.7 million, the first $11.7 million goes into the Credit Shelter Trust, and all of the assets in the JEST get a new income tax basis. So that's an alternative to having separate revocable trusts. Okay, some of the toys I'm going to send you here. Let me see if I can find this and get it to work. One of the toys you'll receive is the EstateView spreadsheet calculator that I'm showing you here. And what you can do is, this is a single individual with a $5 million net worth. And on the left here, we have the estate tax exemption of $11.7 million in green, or if it goes down to half in 2026 in yellow, or if Bernie Sanders gets his way in blue. So what I'm doing is, this person has a $5 million net worth. It's growing at 7% a year. And in 10 years, it'll be not worth $9,192,000. And the estate tax is zero if nothing changes, $754,000 if the exemption goes to half, and $1,928,000 if the exemption goes to $3,500,000. And then I have these switches you can use. What if 7% is too low? What if you think they'll grow at 9%? Okay, go to 9, and all the numbers change. What if I'm not at 5 million? I'm only at 4 million. Okay, go to 4 million. All the numbers change. Wait a minute. I'm saving $100,000 a year, and I'll be able to do it for the next 10 years. Okay, there's your new numbers. So that is one of the spreadsheets that you're going to get. I hope you use it and that you enjoy it. The second spreadsheet that you're going to get is double everything. It's for a married couple. It works exactly the same. And then the third spreadsheet, let me open it. Thank you for your patience while you wait to see if this opens. Are you opening? Well, while we're waiting for that to open, well, let's see here. Try one more time. Nope, Cupert doesn't want to open. Let me show you this. This is a new article that'll be going in Forbes, I hope today, or I guess probably today or tomorrow. If you make a gift, you will save estate tax if you pay gift tax now. And here is the numerical example. You have a $10 million estate. You have no exemption left because you have been so generous. You've given away the whole $11,700,000. If you make a gift of $2 million, you pay a gift tax of $800,000. So your children have $2 million, and you now have $7,200,000. Now you die. The estate tax on $7,200,000 is $2,880,000. The value of the estate after the estate tax is $4,300,000. You already gave them $2 million, so they're getting a total of $6,300,000. But if you had waited to die, even at the same estate, even at the same bracket, they would only receive $6 million. But by gifting now, you're also getting the future growth out of your estate. You're able to pay the income tax for them if you're using an irrevocable trust. And the estate tax rate is likely to go up as opposed to down, in my opinion. So it's a 16% savings to gift now. No one does it, but it's good to know that if you make an aggressive arrangement and it doesn't work out, you're still saving your family nice money. All right, I didn't get as far as I thought I would, but I know a lot of you actually have a life and want to get back to it. So I'm going to scroll back to the first page, and I'm going to answer some of your questions. Only the easy ones, because Brandon's not here to handle the hard ones. Okay. Is it possible to have more than one slat for the same spouse? And yeah, absolutely. We're doing one right now where one slat, a spousal limited access trust, is being funded with non-marital assets. And the clients have a prenuptial agreement. And in this case, the wife has non-marital assets. She's putting it in a slat for her husband. And if he divorces her, he has no benefit from this slat. And her next husband will benefit from the slat. We call that the floating spouse. It has nothing to do with how you look in a bathing suit, by the way. Now, the other slat she's doing is being made from marital assets. It's from money she earned during the marriage. That's going into a separate slat. On divorce, that slat divides into two trusts. One is a continuing slat for her husband, and the other is a trust for her descendants, and she'll control who the trustee of that separate slat is. So yes, you can have multiple slats. You can't have multiple spouses, except maybe in Utah, but you can have multiple slats. Okay. Isn't that separately paid income tax also considered to be a gift to the beneficiaries? No, it is not. Okay, here's another question. What would happen under the Bernie Sanders plan? Well, the first thing that would happen is I'd probably buy a Ferrari because I'd be so wealthy from doing so many estate plans. But the second thing that would happen is your exemption would go down next year to $3,500,000, and your gift tax exemption would go down to $1 million. You wouldn't be able to use valuation discounts after the bill is passed, if it ever was passed, and you wouldn't be able to set up new trusts that are disregarded for income tax purposes. So I would be very, very sad. I wonder how oncologists feel when they cure the type of cancer that the oncologist treats. That's sometimes how we feel as estate tax professionals. But we're always very glad to help people avoid federal estate tax. Okay, Lori, I apologize. I see you emailed a question about gift tax on land owned by your sister and you in Canada. There is a wonderful wonderful lawyer named Ed Northwood, and I'm going to send you an introduction to him. And he is a board certified tax lawyer in both the United States and Canada, and the only person in the entire world who I believe understands all of that. But from a US standpoint, if you gift Canadian property or anything anywhere worldwide, you are considered to have made a gift. The question, though, is what your Canadian tax situation will be. Can I elaborate on why the income tax deduction for the CLUT are higher than the charitable deduction? It's the same. So I put $1 million into a charitable lead annuity trust, and that charitable lead annuity trust will pay 11% of its value. So I put $1 million in, it's going to pay $111,000 a year to charity for 10 years, and then whatever's left in there after the 10 years is going to go to my daughter. I'm going to get, if I draft it properly, I'm going to get $1 million income tax deduction upon funding. I'm going to pay the income tax on the income during the 10 years, but there won't be any income if it's all in growth stocks that don't pay dividends. And then if I use an LLC arrangement, I set $1 million. What if I put $1.5 million in an LLC? I gift the 99% non-voting member interest in the LLC to the CLAT. The CLAT really starts with $1.5 million conceptually. At the end of 10 years, it's got $600,000 or $700,000 left in it, and everybody's happy. It's the Jacqueline Onassis Kennedy plan. She gave her children the option of either receiving their inheritance or disclaiming into CLATs. They chose to disclaim into CLATs, but it was still a good idea, and she had very good intentions. Can a properly structured sale of term insurance to an ILET circumvent the 3-year rule? Yes, Elliot, it absolutely can. When clients want to transfer real estate and avoid the 3-year rule, we do have it sold to the irrevocable life insurance trust. Jim would like to see our draft article, and it will be sent to you, Jim, the Morissette draft article. Also, we have another article we hope you'll read, and it's called Slatopedia, like encyclopedia, but not nearly as good. And that's also, I believe, being sent in an hour. What if a beneficiary of a 529 plan gets a scholarship and the owner takes the money back and gives to the beneficiary of the plan? Would that be another taxable gift? I would think so. Don't take it back, Jack. And by the way, I prefer that you make a gift to an LLC, sell the discounted LLC interest to a SLAT or a trust, get a huge, nice discount, and then have the LLC buy the 529 plan to get the income tax advantages. That's what I like about 529 plans. Okay, regarding 2036, with respect to your idea of transferring an LLC to a SLAT after you're naming self the lifetime manager, does 2036 not catch that? The answer is I could be the manager of the LLC, but not have the ability to determine if and when there will be a liquidation or distribution to the trustee. And since I control who the trustee is, I don't have to make a liquidation or distribution. I'm the signer on the account. The trustee says, give me all the money. I want to spend it to pay myself trustee fees. And I say no, and you're fired. You are no longer the trustee. Okay, here, what do you charge to do bar mitzvahs with the dummy? And well, the dummy is $3,000, but I'm not able to go because I'm always doing these talks. No reason to file an estate tax return if under the exemption amount, unless over single exemption amount, but under double, want to preserve portability. Well, Sharon, if you want to preserve the portability allowance, then you'd have to file the estate tax return. So at least all of us estate tax professionals can share in the opportunity of getting that portability allowance. All right, I think that answers all of the easy questions. If I neglected to answer your question and you would like for me to answer your question, please feel free to send me an email and I'll be glad to send it. We really, really do appreciate all of your questions, all of your comments. And because it's Memorial Day, I thought I would close with something that has nothing to do with tax or estate planning. It's just one of my favorite stories, and it may have to do with Memorial Day, it may not. So there's a farmer 300 years ago, and he's a very, very poor farmer. And in his village are people, and he borrows money from everyone in the village. He builds a fence, and he buys a stallion. He pledges everything he has to buy the stallion. And all the villagers come up to him and say, "What a beautiful stallion. You're going to get the stud fees. We hope you do so well. And you got such a good buy on the stallion." And he says, "Good thing, bad thing. Who knows?" Well, the stallion breaks through the fence. He wakes up one morning, the stallion's gone. And all the people in the village come and say, "Well, now you owe us all this money. We're so sad for you." "Good thing, bad thing," he says. "Who knows?" So then a week later, the stallion comes back, followed by 9 mares, goes right back into the fenced area. He and his son fix the fence. Now they have a stallion and 9 mares. The stallion's very happy. The villagers come and say, "You're so lucky. You're the richest man in the village now. A stallion and 9 mares." And he says, "Good thing, bad thing. Who knows?" Well, his son is breaking one of the mares and falls off and breaks his leg. And they repair the leg, but he can't bend the knee. So he's got a lame leg. And the villagers come and say, "Hey, we're so sorry. That's so terrible. Your son will never be able to marry. He's not going to be able to break horses." And the farmer says, "Good thing, bad thing. Who knows?" Next, the Tsar declares war. The army shows up, takes every able young man to fight in the army. Can't take the son of the farmer. The villagers come to the farmer and they say, "Oh, you're so lucky. We've lost our sons. You're the only one in the village who has a son." And the man says, of course, "Good thing, bad thing. Who knows?" So the moral of this story is when something happens, whether it seems at first to be a good thing or a bad thing, it may turn out to be a good thing. The pain comes when you put the label on the event. So when some ridiculous, dumb little thing happens, it's an opportunity to fix it so it won't happen again. It's the universe testing you. It's possibly the setup for you to have a wonderful opportunity to do something very neat and very original. But don't let a little event ruin your day, because even a big negative event, if you make the lemon out of the lemonade, if you make the lemonade out of the lemon, then wonderful, wonderful things can happen. So I hope you'll contemplate that for Memorial Day. And maybe, and I'll tell you this is interesting. I did a lot of very aggressive very aggressive creditor protection planning in 2008, 9, and 10. And all of it correlated with estate tax planning. And then the families recovered, and a number of them saved more in estate tax when their loved ones died after that than they had lost in the recession. So if taxes go up and you have to change your strategy and you have to get tougher and you have to spend less, good thing, bad thing, who knows? So let me know your thoughts, questions, and comments. Have a fantastic Memorial Day, and thanks again for all you do for others.